Hearing the appeal, Lee-Hirons against Secretary of State for Justice.
My Lady, my Lords, on the 11th of June 2012, Dale Lee-Hirons was conditionally discharged from hospital, having been at that stage in hospital under the Mental Health Act for a period of some 6 years. His liberty had been hard won. His case had been heard in the first-tier tribunal, had gone up to the upper tribunal, back to the first-tier tribunal, but finally in August of 2011, following a lengthy hearing, a detailed examination of medical evidence and the provision of detailed reasons, the tribunal concluded he could be discharged conditionally subject to suitable arrangements being made. Those arrangements took some time to put into effect and were finally approved in April 2012, and his discharge took effect, as I say, on the 11th of June 2012. Less than 6 weeks later, Mr. Lee-Hirons was recalled to hospital pursuant to the exercise of the Secretary of State's executive power under the Mental Health Act, section 42(3). And in consequence of that, he was once again deprived of his liberty in a psychiatric hospital and subject to the full regime of the Mental Health Act. Critically, for the purposes of this appeal, he was not told why his liberty had been removed again for some 15 days, other than a passing reference to there having been a deterioration in his mental state. And by this appeal, he seeks to establish the right to be provided with adequate reasons at the time of his recall. My submissions will be structured into 3 sections, which effectively follow the sequence of the arguments in the written case, although I'm not going to take the court to the written case. I'm going to deal first of all with the common law position, then with the position under Article 5, and then very much more briefly with the question of relief. Dealing therefore first of all with the common law duty to give reasons. Our case in a nutshell is that when the Secretary of State exercises the power under section 42(3) of the Mental Health Act to recall a patient to hospital, he is obliged to provide to the patient at the time of recall adequate reasons for that decision, unless the patient's condition or behaviour or the circumstances in which recall has to be effected render that practically unachievable, in which case we say the reasons must be explained as soon as possible thereafter. In terms of the common law, we reach that conclusion by the following route. Where an act confers an administrative power, there is a presumption it will be exercised in a manner which is fair in all the circumstances. That's duty, and I'll take my lords and my ladies shortly to the case law. What fairness demands is dependent upon the context of the decision. We derive that from duty again. There is a duty to give reasons where the subject matter of the decision is an interest as highly regarded as personal liberty, and we see that from the Court of Appeal's decision in Wooder. And the context of this particular decision, a deprivation of liberty pursuant to an exercise of executive power with no other procedural safeguards, that context points, we say, to a need for reasons to be provided at the earliest opportunity, which will usually be at the time of recall. The duty to give reasons, it's well established, is a duty to provide reasons that are proper, adequate and intelligible, and we derive that from countless cases. The case in the authorities bundle, it's Ermakov. That follows in any event as a matter of common sense. A duty to give reasons would be rendered nugatory if it could be discharged by providing reasons that were inadequate, unintelligible or improper. And then the failure to provide such reasons, i.e. adequate, proper and intelligible reasons, which I'll use the shorthand adequate reasons to convey, has the effect of rendering the decision unlawful, and we rely upon the case of Lumba for that purpose. No doubt my learned friend will clarify the respondent's position in due course, but it appears to us from the respondent's written case that the Secretary of State now accepts, contrary to his position in the courts below, that it is a precondition for the legality of detention that a patient is given some information about the grounds for recall. And I derived that in particular from my learned friend's case at paragraph 45, at page MS89. I don't ask the court to turn it up at this stage. If so, then the issue between us narrows to this, whether informing the appellant that he was being recalled to hospital because of a deterioration in his mental state was an adequate explanation of the reason why he was losing his liberty. And we submit, as the court will have seen from our written case, that this brief statement demonstrably does not amount to the provision of adequate reasons, and I'll return to that obviously in due course. And I start then by taking the court, I hope fairly quickly, through some of the case law. I'm conscious that the court is likely to be familiar with the majority of the common law cases in any event. Starting with Doody, that's volume 1 of the Authorities Bundle, tab 5, and it's MS page 624. I'm not going to trouble the court with the facts of any of these cases. If my lady and my lords would turn to page 653, MS 653, in the judgment of Lord Mustell, between D and G, there is the famous and oft-cited passage setting out a number of principles, and between D and D, the first of those principles, where an Act of Parliament confers an administrative power, there's a presumption it will be exercised in a manner fair in all the circumstances. 2, the standards of fairness are not immutable. They may change with the passage of time, both in the general and in their application to decisions of a particular type. 3, the principles of fairness are not to be applied by rote identically in every situation, dependent upon the context of the decision, and this is to be taken into account in all its aspects. 4, an essential feature of the context is the statute, which creates the discretion, and the shape of the legal and administrative system within which the decision is taken. 5 refers to representations, not the key issue here. And then 6 refers to the need of a person to know what factors may weigh against his interests. So that's a broad statement of principle from Lord Mustell. And there's just one further passage in Doody I invite the court to look at MS 657. It's the bottom of the page at H, where Lord Mustell refers to the general shape of the administrative regime, the imperatives of the public interest, and then says this: the Secretary of State ought to implement the scheme as fairly as he can. The giving of reasons may be inconvenient, but I can see no ground at all why it should be against the public interest. Indeed, rather the reverse. This being so, I would ask simply, is refusal to give reasons fair? I would answer without hesitation that it is not. The second authority I invite the court to look at is Christie and Lichinsky, same volume of the Authorities Bundle, tab 4, MS 591. And picking up the relevant passages in the judgment of Viscount Simon at MS 602, in the final paragraph on that page, second line down, we see the issue that the court was there considering. If a policeman arrests without warrant when he entertains a reasonable suspicion of felony, is he under a duty to inform the suspect of the nature of the charge? And if he does not do so, is the detention a false imprisonment? And then on the following page, almost halfway down, I hope my lady and my lords will see the sentence beginning, all this is for the obvious purpose of securing that a citizen who is prima facie entitled to personal freedom should know why for the time being his personal freedom is interfered with. And then we have the statement of principle at MS 605 to 606. It starts halfway down page 605, when Viscount Simon sets out a series of numbered propositions, obviously here in the context of a policeman arresting someone on suspicion of crime. 1, if a policeman arrests without warrant, etc., he must in ordinary circumstances inform the person arrested of the true ground of arrest. He's not entitled to keep the reason to himself or give a reason which is not the true reason. In other words, a citizen is entitled to know on what charge or on suspicion of what crime he's seized. 2, if the citizen is not so informed but is nevertheless seized, the policeman, apart from certain exceptions, is liable for false imprisonment. 3, the requirement that the person arrested should be informed of the reason naturally does not exist. If circumstances are such, he must know the general nature of the alleged offence for which he's detained. 4, the requirement does not mean that technical or precise language need be used. The matter is a matter of substance, and then this turns on the elementary proposition that in this country, a person is prima facie entitled to his freedom and is only required to submit to restraint on his freedom if he knows in substance the reason why it's claimed that this restraint should be imposed. And then at numbered point 5 over the page, page 606, there is the qualification which we entirely accept, that the person arrested can't complain he hasn't been supplied with the information if he himself produces the situation which makes it practically impossible to inform him, e.g. by immediate counterattack or by running away.
Is there a distinction? There may not be, I'm only asking the question, between somebody in the position with which we are concerned in Christian Liczynski, which is a person who's entitled to his freedom. There are no prior constraints upon that person's liberty. And a person such as the appellant in this case, who has been deprived of his liberty by order of a court order which imposes upon him primarily deprivation of his liberty in hospital, but secondarily subject to the possibility of his being conditionally discharged, subject to a power of recall, and eventually possibly the restrictions being lifted. Is there a distinction between such a person who already has a very substantial constraint on his liberty and a person who has no such constraint?
In my submission, my lady, no. A deprivation of liberty is still a deprivation of liberty in those circumstances. The fact that, indeed, his freedoms have already been curtailed to some extent through the conditions of discharge does not mean that what then happens to him is not a significant and serious invasion of his right to personal freedom. He had, of course, been deprived of his liberty for a period of time pursuant to the Section 3741 order in hospital, but as of the 11th of June 2012, he was no longer a detained patient.
But he was someone who knew that he was liable to recall.
He was someone who knew, or can be taken to have known, that the Secretary of State enjoys a power to recall. Yes, liable to recall in the sense that the power existed, but nonetheless someone who had been given after many years their liberty back. And so we say there is no material distinction between those two situations, my lady.
Was he supplied with, as prisoners on licence were supplied with, copies of the conditions of his discharge? He must have known perfectly well what those conditions were.
Yes, he would have known what the conditions of discharge were, because that's part and parcel of the tribunal's reasoning and part of the tribunal decision. It may also have been supplied by way of a separate document.
Well, I think that's of some interest. And the other thing is, was he provided with information as to the power of recall? Again, this is all part of the code of practice, or the practice it should happen.
My lady, I don't think I've seen any evidence that he was provided with specific information about the power of recall. I need to check whether the tribunal decision, which is in the bundle, said anything in relation to that. I don't think there's any evidence one way or another necessarily that deals with that precise point. I think the evidence does establish that he was aware in general terms that a power of recall existed.
Ms. Richards, obviously you're coming later to analyse the delay in the failure of fuller reasons,
yes.
But you're not there yet.
No.
You're talking about the 19th of July.
Yes.
When on interview, I mean, it was very laconic for him to be told that he was being recalled because of a deterioration in his mental health. But on that day, in those circumstances, what more are you saying was legally required?
As a matter of principle, what I say was legally required, my lord, is the provision of adequate reasons, In terms of what was actually adequate on the facts of that case, if I may come back to that when I deal with the facts,
Well,
my
do.
Lord, and answer my Lord's question at that point, because I've been
Absolutely.
proposing to do so once I'd taken my Lord's and my Lady to the
Very well.
evidence.
Just to pursue Lady Hale's line of questioning, what is the relevance, you may say none, of the fact that a warrant for his recall was issued on the day, so that those who detained him were acting pursuant to a warrant that had been issued?
The only relevance of that, my Lord, is that no claim for unlawful detention could lie against the hospital. There is a wealth of case law in a number of contexts, but including the mental health context, which looks at the role of the first actor and the second actor.
Yes.
There's a Court of Appeal decision, which I think my Lord
Yes.
is probably well
The
aware of,
judgment.
the Hackney case,
Yes.
which looks at that. And so in that case, I think a procedural defect in terms of a failure to consult the nearest relative meant that there was unlawful detention vis-à-vis the local authority, but not vis-à-vis the hospital, which was entitled to rely upon the authority that was given to it in the form of the forms that were supplied to the hospital. So the warrant, on its face a valid warrant, was a proper basis for the hospital to detain him, and it's the reason why we bring no claim against the hospital.
Well, there's a specific provision in the Mental Health Act to that effect, is there not?
There is. But that does not deal with the position, as it were, of the first actor, of the decision maker who issues the warrant and decides to exercise the power of recall. And it's pursuant to that we say there is obviously both the failure of reasons and the consequence of unlawful detention.
The Secretary of State relies on the person who's carrying out the detention to give the explanation. Who is that person an officer or employee of?
The responsible clinician is an employee of the hospital where the patient is recalled to. In this case, I think it's Partnerships in Care. In other cases, it may be an NHS trust. Yes, the Secretary of State ordinarily relies upon someone else to undertake the actual task.
I'm just wondering if there is a failure on the part of the Secretary of State, because if the Secretary of State properly issues a warrant, then query whether the Secretary of State can be held to be acting unlawfully if the person who executes it fails to give the requisite information.
Well, I can deal with that a little further when I deal with the facts, but the position here is the exercise of executive power is by the Secretary of State. The duty to provide reasons is a duty imposed upon the Secretary of State. There may be a number of different ways in which that duty can be discharged. Indeed, the current Mental Health Code of Practice provides that the warrant issued by the Secretary of State will detail the reasons, although there's a degree of confusion and I think a degree of incoherence about what the Secretary of State's current practice is in that regard. But that's what the Mental Health Code of Practice says. That's one way of ensuring reasons are provided. Another way is through communication by another.
Do we know who actually executed the warrant in this case? It's not in the Statement of Facts and Issues.
The police attended with Mr. Hart, the social supervisor. The warrant was sent through to Mr. Hart, as I understand it, the social supervisor whose reasons were effectively, for recommending discharge, were effectively the reasons endorsed by the Secretary of State or adopted by the Secretary of State. And the warrant was sent to him. I think the factual position is he arranged for the police to attend for the purpose of transporting the appellant then to hospital.
You might, I suppose, argue that if there's an obligation to ensure that proper reasons are given, the obligation attaches to the Secretary of State in issuing the warrant. And if it's not done properly, then the breach attaches to the Secretary of State. It's, if you like, a non-delegable duty.
My Lord, that is our submission. Practically, there may be a number of different ways in which he, the Secretary of State, can arrange for the provision of reasons. On the fact of this case, we say it would have been through the mechanism of Mr. Hart, or through ensuring, at the very latest, that the information was provided to the responsible clinician, so that at the point at which Mr. Lee-Hirons arrived at the hospital, that information was shared with him. As we shall see when we get to the facts, the responsible clinician had been left in ignorance. He himself asked the appellant that evening, "Why have you been recalled?" And the Secretary of State failed, in fact, to send the proper information to the responsible clinician. But there are a number of different ways practically in which it can be achieved, but the legal responsibility is the Secretary of State's, because it's the Secretary of State who is exercising the power under Section 42(3). My learned friend observes, by reference to Christine Lechinsky, and with this we agree, that the reasons that are provided do not have to be extensive or take any particular form. But we say they must be adequate, as that concept is generally understood in public law terms, and must deal with the substance of the decision.
Well, what does adequate connote in these circumstances? Does that mean that adequacy is to be judged by the opportunity given to the person detained to make informed representations on his detention, or does it mean some other standard?
Adequacy means that sufficient information must be provided about the essence of the reasons, the reasoning process, to enable the individual to understand why his liberty has been removed, and to be able to take steps to challenge that or seek a review of it.
Do you say that the warrant has to specify the ground of recall?
At the time of this decision, the Mental Health Act Code of Practice, as far as I can tell, it's quite hard to track down the current versions, but certainly the 2008 Mental Health Act Code of Practice was silent on this. The current Code of Practice says that the warrant will detail the reasons.
Yeah. But there's not only the Mental Health Act Code of Practice, there is, of course, the Secretary of State, I think we should say, that own practice and policy, which is, I believe, published.
Yes, it is, and I will be coming to that.
Yeah.
But you're not saying that either the implication of a statute or the common law supplying the omission of the statute requires the ground to be specified in the warrant?
I'm not saying that that's the only way in which the duty can be discharged. This is one way in which the duty could be discharged, provided, of course, that the warrant is provided to the patient and that the patient's attention is drawn to what's set out there.
There are so many different levels, aren't there, as to what can be done and what must be done and when. If one's thinking about the Christian Lechinsky situation, which was an arrest without warrant, the requirement was to tell the person accurately what they were arresting them for. And it would have been enough to say, I am arresting you on reasonable suspicion of murder. And that would have been enough, wouldn't it, in Christian Lechinsky?
Yes.
And the person arresting under a Secretary of State's warrant could say, I am detaining you pursuant to a Secretary of State's warrant. That would be the legal ground for the detention. Or they could say, I am detaining you pursuant to a Secretary of State's warrant, which has been issued because your mental condition has deteriorated. That would be another level down. And another level would be, I am arresting you pursuant to a Secretary of State's warrant because your mental condition has deteriorated in the following blankety-blank ways. It's a lot of very different things we're talking about here, aren't we? We're talking about the legal justification, we're talking about the headline justification, we're talking about reasons, which is somewhat different.
Yes, and obviously our focus is upon the provision of adequate reasons, which we say requires more than either the legal ground or a statement of the kind that was delivered here, but requires something less than a full articulation of every factor that had been considered and every piece of evidence. But
is there not a distinction to be drawn between what happens when the warrant is actually executed and what should happen within 3 days thereafter?
Well, in fact, the Secretary of State's policy is as soon as possible,
Yeah.
and in any event within 3 days.
Exactly.
For the patient in the community, and his policy in relation to patients who may already be in hospital or in prison is actually they're told at the same time what the
Well, we're
reasons
talking
are.
about a patient in the community, aren't we?
We are, although the basis for the distinction we suggest is perhaps a little dubious.
Well, you're not attacking the policy at this moment, are you?
There isn't a freestanding challenge to the policy, no, my lady.
So let's stick with what we've got.
Yes.
It's quite complicated enough. But you're saying that, in fact, the reasons should have been communicated at the moment that the warrant was executed.
We say at the earliest possible opportunity, having regard, obviously, to the issues of practicability that I've identified, and that, indeed the House of Lords and Christie and Lechinsky identified, if there's counter-attack, if the person runs away, and so on, then different considerations arise. But we say either, and this is our primary case, at that point when the warrant is effected, and in terms of the facts of this case, there's absolutely no reason whatsoever why that couldn't have been done, or, as the Secretary of State's policy stipulates, at the latest, at the point at which the person arrives in hospital.
How would it have been done at the point of... See, I completely understand your case, that adequate reasons should have been given at the earliest practical opportunity, and in any event within 3 days. Completely understand that. Trying to get my head round what happens when you actually are putting your hand on a chap's shoulder and saying, I've got a warrant here, which from the Secretary of State, you know the Secretary of State's got power to recall you to hospital. He's recalling you to hospital. Come along. Are you saying that the person should have read out Mr. Hart's report? Are you saying the person should have handed over Mr. Hart's report? What are you saying should have happened at that point?
At that point, on the facts of this case, because, as I say, we recognise it maybe if the person has absconded and is being seized by a police constable in a public place, different considerations may arise, and then the earliest opportunity may be the point at which the person is in hospital. On the facts of this case, the fact of being recalled and the implementation of the warrant took place in the supported accommodation in which the appellant had been residing. It was Mr. Hart who was well aware of the reasons for the Secretary of State's decision, because it was his recommendation upon which the Secretary of State was acting.
He'd made the report.
He'd made the report. It's not his responsibility, it's the Secretary of State's, but he's the conduit through which the Secretary of State, we say, could, on the facts of this case, have complied with his legal obligation. A meeting took place in the late afternoon, early evening, on the date in question, on the 19th of July. In this supported accommodation, there was a police officer or more in attendance to actually effect the transfer. Mr. Hart was there. The appellant was, the evidence establishes, calm and compliant. The phrase used by Mr. Hart when reporting to Mr. Elliott in the Secretary of State's mental health casework team later on is that it was effected with ease, there was no need for restraint, and that the appellant got into the police van without a fuss.
Well, Ms. Richards, of course, I was asking you about this earlier, and you told me very politely
I was
wait, and so I have been waiting. But I do want to, at some stage, press you with Lady Hale's demand that you should actually fill out the scenario. Because, I mean, I wouldn't find it very easy to summarise Mr. Hart's statement, but I suppose if one had to, it would be to say to your client, that we think there's been a deterioration in your mental health, and in particular, we're very worried about what we regard as your delusional statements. Oh, what delusional statements? I mean, you can imagine the deep water and the raising of temperature that sort of thing generates just when the van is ready to take him from Lancaster to Manchester.
My Lord, we say equally imagine the confusion, distress and the potential consequence of that upon a patient's behaviour and conduct, a mental state of being given no information at all, having won this liberty back after many years, of simply being told your mental state's deteriorated, you're back off to hospital, the Secretary of State's decided.
Well, that's why we completely understand your case about adequate reasons within a short time thereafter. But the point that is troubling,
Yes.
Lord Wilson and me, is thinking about the practicalities of an arrest. What would the police officer have thought if they descended into a lengthy debate about whether he had or had not done this? I mean, I can imagine the police officer saying, tell him what's what, but nothing more.
One can imagine the police officer perhaps not wanting to get involved at all in that, and we're not suggesting that the police officer would have been the means for the provision of information. Mr. Elliott's statement identifies, and this was the point I was going to come back to, but I can deal with it now.
Sorry, we have taken
That's quite all right. Identifies 4 reasons for recall, of which one is deterioration in mental state. The second is risk of harm to the public, which the guidance says actually is the key issue and wasn't mentioned in the oral communication of reasons at all. The third was non-compliance with the requirements of the social supervisor, and the fourth, non-compliance with medication. So 4 discrete reasons given by Mr. Elliott. I will take my lords and my lady to the page references and, to this in a relatively short while.
And you're saying that all of that should have been explained to him before he was actually taken off to hospital?
It would take a minute or two, at most, to provide the explanation that we say required to be given to an individual whose liberty is being taken away from them.
Well, I do just wonder about that. You say it would take a minute or two. When you read your client's statement, his first statement, in Appendix Part 2 at page 275, I do find myself questioning whether, if he'd been told in detail what was in Mr. Hart's report, this would have been a 1 to 2 minute conversation.
Well,
it would have turned, I suspect, into a lengthy argument.
Well, my lord may be referring to the subsequent discussion that took place on the 3rd of August, which was the first time that he learned.
But I mean, this has the attraction as a statement that you can hear your client speaking in it, not like so many witness statements which have been prepared by solicitors and processed and manicured to the point where you wonder what the person is really saying. I mean, your client's personality comes out through this. And just reading it, I then try and imagine him being given a 90-second summary of the reasons for detention and that being that.
Well, my lord, the fact that it may be difficult in the context of the management of psychiatric patients, difficult to communicate without some form of reaction, what the reasons are for a particular course, whether it's recall or the imposition of invasive compulsory treatment, does not mean it should not be done. We'll never know how the appellant would have responded to what we say was required in what we say was the relatively calm and confined environment of the accommodation with Mr. Hart present, with a summary of what the Secretary of State's reasoning process was, because it didn't happen. And so we can speculate, but we say that's not a good reason, in our respectful submission, to say that the duty does not arise when you are talking about something as fundamental as deprivation of liberty.
Do we have the warrant?
I'm sorry, my lord.
Do we have the warrant in our papers?
Yes.
Yes, it's very...
MS 147.
Could you give the appendix pagination number?
It's the core bundle.
No, I'm not working from the core bundle.
Ah.
I'm working from the separate.
It's page
Yes,
41, I think, in Appendix Part 1.
Yep. Thank you very much.
And so the warrant is baldly that, a warrant for recall. It identifies the legal power and the place to which the hospital to which the patient is being taken. And just while I'm dealing with the practicalities, I think I referred earlier to a communication between Mr. Hart and Mr. Elliott from the 19th of July, setting out what had happened. It's at 329 of Appendix 2.
Sorry, page again.
Page 329 of
Thank you very much.
Part 2. And it's at the top of that page. Many thanks for your assistance this afternoon. It was greatly appreciated. The warrant was executed at 18:23 hours. Dale was informed of the reasons for his recall. I take that to be a reference to the deterioration in mental state, because I think it's common ground that there was
I'm sorry, can you give me the MS number?
I'm sorry, it's Appendix Part 2, so I don't have it with an MS number.
I see.
Oh, it will have an MS number.
I'm afraid I don't have... 435. Thank you.
Thank you very much.
He was informed of the reasons, the place to which he was being recalled, informed there'd be an automatic referral. Suffice to say, he was not happy with the decision to recall him. He'd said to staff this morning he believed recall to be inevitable. I do not think it came as too much of a surprise, and maybe some factual dispute about that, but it doesn't matter. The actual removal of him from Longcroft was easy. He did not need restraining by the police, and he got into the van without much fuss. Now that's the response of the appellant to the decision to deprive him of his liberty. There's no particular reason, we say, why one should infer that had he been given more information than he was, he would have reacted adversely. That would be speculation in my respectful submission, and there's no foundation for it on the facts of this case.
Well, in any event, it's either right in your submission that the reasons have to be given, in which case the anticipated reaction of the individual to be detained doesn't bear on the question of whether proper reason should be given. In other words, you can't be absolved of the legal obligation if it exists, because the individual concerned may react badly.
My Lord, we would say that. I would also add, in fact, there's no evidence in this case that the Secretary of State would have given greater reasons, but having reflected on the matter briefly with Mr. Hart, decided on the facts of this case, because of how the appellant might react, they shouldn't be given. And then in any event, we say, of course, as I know my lady, my lords understand, that on any view, the reasons should have been provided to him very shortly thereafter, in other words, the same day when he arrived at the hospital that evening. I don't know the precise time of his arrival, but it was not, I think, a lengthy journey. And that was the second earliest opportunity that should have been taken. My lords, my lady, if I can just briefly return to the case law.
Yes, we took you a long way away from
Yes,
that. I'm sorry.
That's quite all right. I'm just conscious of the time. Can I just briefly take my lords and my lady to Ermakov, which is Authorities Bundle Volume 1, Tab 6, MS 662. And I draw attention to this for the assistance in terms of what's meant by adequate reasons. It's at page 669 and 670, just below letter F. First, to the obligation being imposed, so persons affected may know why they've won or lost, may be able to judge whether the decision is valid and therefore unchallengeable, or invalid and therefore open to challenge. And then there's a reference to the description given by Sir Thomas Bingham, just below H, the obligation must impose a duty to give reasons which are intelligible and which convey to the applicant the reasons why the application has been rejected. Obviously, we would say here the reason why the recall is being affected. And top of the next page, the famous statement, they're proper, adequate and intelligible. And can
that
be
was in the context of homelessness decision making.
Yes. Obviously, what exactly is adequate on the facts of any individual case will turn both on the facts of the case and on the particular context. But the principle, the standard which has to be met is proper, adequate and intelligible. And that's not the same as full, detailed or lengthy. And then, finally, by way of case law at this stage of my submissions, Wooder and Fegeter, that's tab 8 of the same volume, MS 694. This is a Mental Health Act case. The context of the decision was a decision by a second opinion appointed doctor that a patient be given medical treatment against his will. And then the statements of principle start on MS 701 in the judgment of Lord Justice Brooke. And it's paragraphs 23 through to 24. I won't read them out. Paragraph 22 identifies that we have to consider the requirements of fairness, take into account the character of the decision-making body, the kind of decision, and the statutory or other framework. And then at 24, one of the classes of case where the common law implies a duty to give reasons is where the subject matter is an interest so highly regarded by the law, for example, personal liberty, that fairness requires that reasons, at least for the particular decisions, be given as of right. And that's reinforced in the judgment of the Court of Appeal by the fact, and we see this at the top of page 702, that these were decisions which sanctioned the violation of the autonomy of a competent adult patient. And then at 29, bottom of page 702, the decision maker is not required to dot every I and cross every T when giving reasons, so long as he gives his reasons clearly on what he reasonably regards as the substantive points on which he formed his clinical judgment. And we say that's the applicable standard here. And I just ask my lords and my lady to note also from the judgment of Lord Justice Sedley at MS 704, paragraph 38, his reference there to the decision-maker being a person equipped in the public interest with statutory powers which impact directly on someone's physical and moral autonomy. Any such power carries a heavy burden of responsibility. And we would echo that in relation to the context of the present decision, which results in recall to hospital and potentially indefinite detention. So we say, first of all, it's obvious from that case law and the principles to which I've referred, that the common law will impose as a matter of fairness a duty on the Secretary of State to provide adequate reasons for the exercise of the Section 42(3) recall power. We submit further that those reasons are required at the time of recall, subject to the considerations of practically achieving that to which I've referred, or at the earliest opportunity thereafter. And we make the following points in support of that submission. Firstly, the giving of reasons is widely regarded as one of the principles of good administration, in that it encourages a careful examination of the issues, the elimination of extraneous considerations, and consistency in decision-making. And we say the giving of reasons at the time of the decision, rather than ex post facto, focuses the decision-maker's mind on exactly what it is that has to be decided within what legal framework and according to what material. Secondly, we say that the timely provision of reasons is a proper acknowledgement of the gravity of a decision of this kind, i.e. the deprivation of liberty, and that it's arbitrary to have one's status redefined so fundamentally without an adequate explanation of the reasons for that action. Thirdly, it enables the person who has been deprived of their liberty to know as soon as possible whether there is a basis for challenge and to take steps to mount such a challenge. And time is of the essence, we say, when a person's liberty has been removed. Fourthly, and turning to the particular statutory context of the recall decision, the recall of a conditionally discharged patient is one of the most significant decisions taken by the Secretary of State. It deprives a patient of their liberty for an indefinite period, and that's important, and as a sectioned patient then renders them liable to accept medical treatment without their consent under the provisions of the Mental Health Act. Fifthly, it's an exercise of executive power which takes place without any participation by the affected person or consultation with them or indeed direct contact with them, which brings to an end their liberty in circumstances where a judicial authority, in the form of the first-tier tribunal, will have previously found that person was entitled to their liberty, in this case, on the facts of this case, only a few weeks previously. And sixth, and perhaps most important in terms of the context of this particular kind of decision, there is an absence of other procedural safeguards. The Section 42(3) power stands on its own. There is no hearing. The duration of the detention, and contrast here what may happen when a person is arrested on suspicion of a criminal offence, clear confines in terms of how long that person can be held in police custody and they will then be brought before a court. Here, the duration of the detention is potentially indefinite. There are none of the safeguards of the nearest relative procedure, which applies to other forms of compulsory admission under the Mental Health Act. There's none of the range of procedural safeguards that will attend detention under Section 3 of the Mental Health Act or the initial imposition of the Section 37 order. And there's no right of appeal against the decision. There will be a reference that's made by the Secretary of State to the first-tier tribunal, but importantly, when the tribunal then meets to consider the patient's case, which may, as it was on the facts of this case, be months later, they are not reviewing the recall decision. They are looking to see whether on the facts on the day that they meet, on the facts before them, the person at that time meets the detention criteria. So there are no other procedural safeguards, and that's why reasons in this context assume such huge importance. And we say, in short, it's a decision which cries out for reasons to be communicated at the earliest opportunity, which we say is when recall is undertaken, and essentially for the reasons articulated by Viscount Simon and Christian Lee-Hirons. Now, if I can just turn to deal with the Secretary of State's policy, because we say there's some understanding of these imperatives in the Secretary of State's policy. The reference, and I don't think I need to invite my lady and my lords to turn to it unless the court wants to, but it's MS 156 to 162. There are two identical circulars dating now, I think, from the 1990s. They provide that for the patient already in hospital, they're told at the same time both the fact of recall and the reasons, likewise for the patient in prison. And we say that reflects what is the correct approach, that reasons should be given at the time of the recall being undertaken. But the patient in the community is to be told, pursuant to the policy, merely in simple terms that they're being recalled. And then the policy provides that the explanation of reasons should be given as soon as possible after readmission to hospital. And it's in any event within 72 hours. That's the long stop. It's not a policy, but whereby it's provision within 72 hours.
Now, where do we find that?
That's MS 156 to 162. It's in the core volume, and then I can give my lady the appendix details as well.
Starts at 50.
Thank you. Yes, it's page 50 of Appendix Part 1, page 156 of using the MS pagination.
And where does it say about reasons?
It's page 159 MS, page 53 of the internal pagination. And it's stage 1 is you just tell them they're being recalled and they'll be given an explanation later. And then stage 2 is you give the explanation as soon as possible after readmission to hospital. And on any of you, of course, we know that didn't happen here. There's also reference to reasons being given to the nearest relative, but there's in fact no nearest relative for patients who are restricted patients under Part 3 of the Act.
And this is a local authority circular from the Department of Health.
It is, but the Secretary of State in this appeal has put forward this document as representing his policy at the relevant time in relation to the provision of reasons. So although in form it was initially directed at other professionals, it is the Secretary of State's policy now.
Well, I was not thinking that it was directed at other professionals. I mean, it is directed at the people who are likely to be responsible for the people likely to be executing warrants, because we're talking here about social workers, probation officers, as they then were, and prison officers, and the police.
Yes.
So we're talking about the people who, on the ground, are likely to need to do it. But what's interesting me is that it comes from the Department of Health and not from the Home Office, which is what one would have expected, that there would be some Home Office guidance on how the Home Office's powers should be put into effect.
In fact, it's the Secretary of State for Justice, so it's the Ministry of Justice now.
No, I know that, but at this
yes,
time it was the Home Office. That's what I'm...
Yes. The only guidance that there is that emanates from the Secretary of State is guidance about the general criteria that he will apply when taking recall decisions. Perhaps I should just ask you to look at that. It's in part 2 of the appendix at page 376. Sorry, my lord, that's the internal pagination and not the MS pagination, so I'm hoping someone will be able to...
Is there a tab number?
No.
Policy on recalls, yes.
It's... MS 482.
482, thank you very much.
It starts a few pages before that. Ministry of Justice, recall of conditionally discharged restricted patients. And then at what is paragraph 5, under the heading Mental Health Casework Section Policy on Recalls, there is there set out a number of matters which go to the substantive criteria for recall. But there's nothing in this guidance which deals with the provision of reasons or the procedure that should be followed. And you will see from the first bullet point below paragraph 5, the decision on whether to recall largely turns on the degree of risk, gravity and imminence. And second bullet point, recall does not require any evidence of deterioration in the patient's mental state. So in terms of the provision of reasons, what we understand the position to be from the Secretary of State is that those health circulars represent his policy on the provision of reasons. The current position in terms of policy is, we say, more than a little unclear, and I make this not to make some forensic point, but just to underline the importance of having some understanding and clarification from the court as to the legal requirements, because the Court of Appeal recorded in its judgment, I don't ask the court to turn to it, but it's MS 142, paragraph 53, that it was informed by the Secretary of State that his practice had changed and that he would now include in his warrant a brief reason for recall.
Yeah, I'm rather wondering if that should not have been there all along. I mean, if that might not be an answer to this. In Christian Lichinski, the House of Lords explained the practice of stating the charge in a warrant for arrest as going back to Entick and Carrington, that the law didn't recognise general warrants, and so you had to particularise the ground on which somebody was being arrested in the warrant. And I don't suppose, the argument would have to run that Section 42 equally isn't intended to authorise warrants to detain people in hospital without any explanation of the ground on which the warrant's being issued.
And that is now reflected in the current Mental Health Act Code of Practice, although it doesn't appear to be what the Secretary of State told the Court of Appeal his practice was, because the current Mental Health Code of Practice, in its Volume 3 of the Authorities Bundle, tab 39, MS 1679.
I'm sorry,
MS 1679.
1679. Okay.
This is the code of practice that's only just come into
This is the
force.
current Code of Practice, yes, so it didn't apply at the time. At the time, the Code of Practice, as far as we can see, just didn't address this issue at all. And it's paragraph 4.19. And what it there provides for is a brief verbal explanation of the Secretary of State's reasons for recall. And we can argue about what's meant by brief, but we say a verbal explanation that is adequate, and which can be brief on the facts of individual cases, is what the law requires, and we say that appears to be reflected in the code, unless there are exceptional reasons why this is not possible, e.g. violence or distress. And then the Secretary of State's warrant will detail the reasons. Well, that does seem to us to be different from a brief statement of reasons, which is what the Secretary of State told the Court of Appeal his current policy was. But the Secretary of State has, through the Government Legal Department, also confirmed to us on inquiries, and we've dealt with this in a footnote in our written case, to say that he hasn't amended the circulars because he didn't think they needed amending, because he thought they still remained valid. That's footnote 3 in our written case. I don't ask the court to turn it up. So there is a degree of confusion about what the current policy and position is. Now, my learned friend's submission is that what was provided on the 19th of July was adequate by way of an explanation for the detention, and was sufficient to make the appellant's detention lawful. And we see that, I think, from paragraph 4b of my learned friend's case and from paragraph 45. I'm not going to go through the actual reasons of the respondent in detail, but if I can just invite the court's attention, firstly, the report of Mr. Hart, which is MS 148-9, identifies, obviously, a range of factors in particular, the appellant's presentation, distracted, guarded, lack of insight, bizarre behaviour over the preceding 24 hours, reference to absconding and alcohol, reference to the lady AK, and a number of other matters there set out. And we know that was before the Secretary of State when he took his decision. If we then look at Mr. Elliott's witness statement, which is in the core bundle MS 151, it's pages 44 and 45, my lady, of Appendix Part 1. You will see, bottom of page 45, that's MS 151, Mr. Elliott set out the details of his conversation with Mr. Hart, and then it's the last 4 lines where he says this: I'm satisfied there is clear evidence of a deterioration in the patient's mental health, that's factor 1, that an increased risk to the public is being presented, factor 2, that the patient is non-compliant with his medication, factor 3, and the requirements of his supervision in the community, factor 4. and then the decision of recall actioned. And then if we look over the page, MS 152, page 46, paragraph 5 of the statement of Mr. Elliott, you will see he refers to the significance of the decision. And then in the last sentence, about 5 lines from the bottom of the paragraph, he says this: the decision to recall turns on the degree of harm the patient may cause and the current likelihood of that harm occurring, and after careful consideration of the patient's previous history, identified risk indicators and current presentation, decided, I think that must be I decided, that recall was appropriate for public safety and in line with the government's policy. So a number of factors there set out by Mr. Elliott, and what he says about the prominence of risk being the key factor obviously is consistent with the recall guidance which I've shown you. The sole information, as we know, that was given to Mr. Lee-Hirons on the 19th of July, or indeed at any point for the next 15 days, was that there had been a deterioration in his mental state, which is but one of the factors identified by Mr. Elliott. That's the sole information communicated orally. The warrant, we know, contained no reasons. And then if the court just looks at what happened when Mr. Lee-Hirons got to hospital, it's his witness statement at Appendix 2, page 179, and I hope that someone will be able to give me the MS pagination. I'm sorry I don't have the pagination for the second part of the appendix. 285, thank you. Paragraph 7, the appellant says this. So we have the time of arrival, 6:45, so 20 minutes or so after the recall had been, the warrant had been effected.
So this is the claimant's second witness statement?
Yes, it is.
Do we have his first?
Yes, it is in there. I can find the reference to my lady.
It's the previous September, isn't it?
So for present purposes, looking at what he was told, or rather what he wasn't told, we see paragraph 7, it talks about arriving at the hospital. On admission, I was given no explanation as to the reason for my recall by the charge nurse who dealt with my admission. No criticism of the charge nurse because the Secretary of State had failed to provide that information to the hospital. Paragraph 8, I did ask nursing staff why I'd been recalled as I did not understand. I was so unhappy about being recalled I refused to eat initially. And then this, paragraph 9, I was seen later that evening about 9 p.m. by Dr. Kazmi, he's the responsible clinician, who basically asked me why I had been recalled, as he appeared to have no information at all about the reasons. And then the appellant passes on the only information he has. Paragraph 10, he says, I couldn't sleep, I asked for medication to help with this, it was refused. I was nursed in isolation, presumably because they knew nothing about me. 11, he talks about the next day. He says, again, no explanation was given to me as the reasons for my recall. Over the page, paragraph 12, on the 21st of July, so 2 days have passed now, I once again queried the reasons for my admission. Nobody was able to provide that information. Paragraph 13, he's talking about his unhappiness. Again, still no explanation for the reasons. Paragraph 14, not until the 3rd of August that Dr. Kazmi saw me, and this time he read out a statement from Mr. Hart. There is, I think, an error in some of the documentation. The appellant was not given Mr. Hart's report at that time. That wasn't actually provided to him until it was given to his solicitors in October.
Yes, I wondered about that. It's an agreed fact in the statement of facts.
It is, and it's wrong, and I apologise for that. But when one looks at Dr. Kazmi's evidence and the medical notes and the appellant's own evidence, Dr. Kazmi read out and went through the report on the 3rd of August. I don't suggest that the outcome of the appeal turns on that, but I wanted to correct that.
We were asked about his first statement. Do we get that in the same bundle at 275?
Yes. Yes, we do. So you see there the impact that the non-provision of information had upon the appellant in terms of both his own understanding and the care that could be provided to him. And there's just one further document that I should invite the court to look at. It's in the core bundle at MS 154. page 48, using the internal pagination. And it's the Secretary of State's letter to the hospital. And we'll see it says, it's dated 24th of July. Dear Dr. Omar, I'm enclosing a copy of the warrant. And then it says in the second paragraph, you should inform Mr. Lee-Hirons in full as soon as possible after his admission and in any event within 72 hours of the reasons for their recall. Now, we've seen the pro forma of this document, of this type of letter, and the reasons are supposed to be set out there. They weren't. So this letter had, I'm afraid, 3 defects. One, it was sent to the wrong clinician. Dr. Omar was not the responsible clinician. That's perhaps a small point. It's the right hospital.
But he didn't work at the Spinney at all, did he?
I can't remember that without checking, my lord.
I mean, he'd been at Langley House.
No, my lord is absolutely right.
He'd been at Langley House.
He had.
There was a complete confusion
Yes, it was
there.
complete confusion. So it's addressed to a doctor who doesn't work at the hospital.
Quite.
It's sent on the 24th of July, so 5 days have elapsed at this point. And
The writer seems to think that there's been no execution of the warrant.
yes,
But the Ministry of Justice knew perfectly well that there had been.
Mr. Elliott knew that evening.
Quite.
And the letter failed to provide the hospital with any of the reasons that should there have been set out. I won't take my lords and my lady to it, but the sample letter which shows that the letter is supposed to contain reasons is appended to a statement from a Trish Jennings.
Now, this letter was copied, it appears, to the Chief Executive and the Social Supervisor. Who are they? I'm looking at page 49.
The social supervisor would be was Mr. Hart, it's probably still at that time.
Right.
He had been the social supervisor in the community. Chief executive, I assume it's the chief executive of the hospital.
Right.
But I don't know.
But so at least, I mean, the letter would have got to somebody who knew something about the case if the social supervisor were Mr. Hart.
It would, but of course, it would have told Dr. Casmi, the responsible clinician, and those responsible for the appellant's care, absolutely nothing about the reasons for recall. They simply weren't in there. But perhaps I should just show you what the letter's supposed to contain. It's in Appendix Part 2. Page 127, using the internal pagination.
What is it you're asking?
It's just after the statement of Trish Jennings. And the second paragraph says, you should inform X in full as soon as possible after his admission and in any event within 72 hours.
Sorry,
If anybody has
I'm
the memory stick numbers for these documents, it would be very helpful if they could. I know you don't have them, Ms. Richards. You should have, but as you don't, those on the other side do have them. It would be helpful if they could shout out the
I'm very grateful to my
electronic, because
Well,
Lord
Mr.
Kerr
Chairman.
and I try our best to work from the electronic documents.
Thank you.
333.
Thank you.
It would be churlish to remind everyone that the practice
I
direction
know.
does specify in pretty explicit terms.
Yes, I'm sorry. I have the MS documentation references noted for everything apart from this appendix, and I'm sorry for that.
I don't think practice direction makes exceptions for
No, I'm sure it
appendices.
doesn't. And so we see from the second paragraph of the letter that what it's supposed to say is you should inform the patient in full as soon as possible of the reasons for recall, namely that. And that was not in the letter that was sent 5 days after the event to the Spinney Hospital. So in our submission, the reason that was given, and the only reason that the appellant had for 15 days, was manifestly inadequate. It referred to only one of the factors listed in Mr. Elliott's statement.
Well, yes, you say that, and you've identified 4 features, but it may be that they're all interconnected. and the deterioration in mental health may have informed the other three. So it may not be quite as simple as that.
My Lord, I accept obviously that there will be an interconnection.
Yes.
But the point is this: a deterioration in a patient's mental state without more is unlikely to be sufficient to justify recall to hospital. That's clear from the guidance. It's the nature of the risk that's key. And of course, a patient that's been conditionally discharged, patients with psychiatric conditions, their mental states will fluctuate. It is not surprising for a patient's state to deteriorate. What wasn't explained to the appellant was why it was thought his state had deteriorated to such an extent that it necessitated his recall to hospital. And Mr. Elliott states the decision to recall turned on the degree of harm, the risk and the likelihood of that harm occurring. There was no communication of that or of the nature of the concerns to the appellant whatsoever for 15 days. The explanation that was given, we say, would not have been sufficient to enable the appellant to understand or respond to the Secretary of State's concerns or to mount an effective challenge to his detention. Now, the Court of Appeal referred to, and my learned friend in his written cases referred to, the fact that a letter was sent by the appellant's solicitors in the course of August 2012 and said, that the Court of Appeal said, well, you had enough information to mount a challenge. I'm not going to take time going through the detail of what that letter said, but it was with all due apologies to my instructing solicitors, it was a fairly bland and uninformative letter because they had no information. And it asked for the reports upon which the decision was based, which were only provided in early October. And it was at that point the proceedings were issued. It was necessary to have the reasons in order to know whether there was a basis for challenge.
Can you give us a reference to the MS number for the letter?
I don't have it, but I will find it. And I don't have a reference either to the MS number, I'm afraid, or to any other number, but I will find it and provide
Thank you very much.
It couldn't be 323, could it, Ms. Richards, in Appendix 2? I'm afraid I haven't got the MS number.
Thank you.
It is indeed. And you will see bottom of page 324, so that's the second page of the letter, asked to supply all the documentation. And there was a lot of toing and froing, which I really won't go through, which resulted in the documents finally being provided in October. So the appellant was not informed of any factors which caused the respondent to believe on reasonable grounds that something had happened since the first-tier tribunal decision sufficient to require him to be deprived of his liberty again. And no information provided about the aspects of his presentation that caused the respondent to conclude there had been a deterioration in his mental state. And in our respectful submission, those reasons were plainly, or that reason was plainly inadequate, because what he was told would not have enabled him either to understand the nature and basis for the recall or provide him with any basis for taking steps to challenge it. My learned friend has suggested that the Court of Appeal found this initial reason to be adequate. That is not our reading of the Court of Appeal's decision. The Court of Appeal found that overall the duty was discharged at common law. But if my lords and my lady just turn to the Court of Appeal's judgment at MS 138, and I'll just give the paragraph references and page references briefly, if I may, in light of the time. But we say the opening sentence of paragraph 39 on page MS 138, the opening sentence of paragraph 43, MS 139, paragraph 44...
Well, that's within 72 hours, Ms. Richards.
My Lord, yes, but no other reasons were provided. So the...
No. But I'm not sure that the opening sentence of 43 is a finding of breach at the time of recall.
No, I'm not suggesting it was. If the Court of Appeal had found that, obviously we wouldn't be here. I'm simply dealing with the question of adequacy. My learned friend's submission is that what was said to the appellant on the 19th of July was adequate, and he says the Court of Appeal so found. The Court of Appeal did not find that that was an adequate statement. What it found was that it was capable of being effectively elaborated upon at a later stage. But it did not find that that was an adequate statement.
What
It may be that nothing turns on it in any event.
Why is the first sentence of paragraph 39 put conditionally? If X, it would have been Y.
I don't know, because it was the only information provided for 15 days.
It seems curious that, as my Lord points out, because it seems to be implicit that further information was in fact given.
Yes, and it's common ground that it wasn't. And that was common ground before the Court of Appeal. And then, indeed, bottom of page MS 139, paragraph 44, there is reference to there being a breach of the policy to provide an adequate explanation of recall within 72 hours. So again, leaving aside questions of timing and the 72-hour point, it's clear that the Court of Appeal did not regard it as adequate simply to say there was a deterioration in your mental state. And so I make that point only to demonstrate that my learned friend's submission to the contrary is wrong. So, my Lords, before I finish with the common law, I should just deal with what we say is the effect of the failure to give adequate and timely reasons. And there are two cases of significance, both of which I know members of the Court will be familiar with. The first is Lumber, Volume 2, Tab 22, MS 1059. And if the Court turns to paragraphs 66 and 68 on MS 1089, in the judgment of Lord Dyson, I leave, I think, paragraph 66 to stand on its own. And then paragraph 68, and this is looking here at the kind of error that would be sufficiently material to render detention unlawful. Paragraph 68, the error must be one which is material in public law terms. Not every breach of public law is sufficient to give rise to a cause of action in false imprisonment. The breach of public law must bear on and be relevant to the decision to detain. And then two examples given of scenarios which would not be capable of affecting the decision to detain or not to detain. And then over the page, at 76, paragraph 76, page 1091, Christian Lechinsky is referred to, and then at 77, reference is made to the submission being made there by Mr. Beloff that the case should be distinguished. And Lord Dyson says this, just between G and H, I do not see why the failure to provide a detainee with the reasons for the arrest should be regarded as a failure to satisfy a condition precedent to lawful arrest, rather than an unlawful exercise of the power to arrest. In any case, it would be remarkable if such distinctions affected essentially the legality of the detention.
What do you say to the point regarding paragraph 68, that the failure in this case didn't bear on the decision to maintain, to the decision to detain? The decision had been taken, and the Secretary of State had said, please give him the reasons, although the letter was sent to the wrong place.
Well, I say that's not the approach that was taken by Lord Dyson in the Lumber case.
So how do you read his reference to it must bear on the decision to detain?
There must be a sufficient link, and then the question of reasons and procedural safeguards is then expressly dealt with by Lord Dyson at paragraph 77.
If the decision to detain predates the breach of policy, in what way does the breach of policy bear on the decision to detain?
Really, for the reasons given by Lord Dyson, a fundamental failure in terms of procedural fairness or procedural safeguards will be regarded as an unlawful exercise of the power. And Lord Dyson says that in terms in paragraph 77.
Well, have you answered my Lord's question? Bear on, relevant to the decision to detain.
My Lords, in both this case and in the second case that I'm going to take my Lords to in a moment, Cambadsdy or SK, the Supreme Court looked at procedural failures.
They were looking at review decisions about whether to continue to detain.
Well, in Cambadsdy was a review decision. Of course, Lumber at paragraph 77 is expressly dealing with the provision of reason.
But it wasn't what the case was about.
It wasn't what the case was about. No, that's absolutely right, my lady. It was about a failure to, or policy and a secret policy, effectively. But I'm relying upon the observations at paragraph 77 of Lord Dyson. And if I can just take my Lords and my ladies through the cases and then I hope answer my Lord's point more directly. And then at...
The paragraph 77, just sort of highlights the problem. There they were dealing with the giving of reasons, which was a condition precedent to a lawful arrest.
Yes, well, reference was made to Christie and Lachinsky, and of course, part of the answer is in Christie and Lachinsky, the House of Lords made clear that the failure to provide the reason there renders the detention unlawful. So in a sense, one doesn't need Lumber to make out that connection. Christie and Lachinsky does it.
Yeah. So, yes, that is indeed not a Lumber point. It's as you rightly say, either as a matter of common law, it was unlawful because more wasn't said at the time of detention, or if that didn't affect the lawfulness of the initial detention, then Lumber doesn't provide you with a separate reasoning route or reaching an opposite conclusion, does it?
No, Lumber effectively says the same as Christie and Lachinsky in terms at paragraph 77. And then the only other passages in Lumber I wanted to refer the court to, really for the sake of completeness, is MS 1124, paragraph 201, and this is the judgment of my lady. Again, dealing here with procedural requirements. Now, this here deals first of all with Cooper and Wandsworth District Board of Works, which is about prior notification. But if we look at just below E, on page 1124, the lady says this, in other words, there were public law duties inherent in the apparently open-ended statutory power. So the way in which the analysis proceeds, my Lord, in my submission, is that it's the procedural component is regarded as an inherent part of the exercise of the statutory power. And then my lady refers at the end of paragraph 201 to Christie and Lachinsky.
So that he might know whether or not he could resist arrest. Now, that doesn't apply in this case, does it? You're not saying that had fuller reasons been given, which were inadequate, your client could have resisted recall?
No, I don't say that. And indeed, it's in my respectful submission, I don't need to say that because the principle doesn't turn upon, in my submission, how an individual might or might not have responded to the executive decision. The other passage is the judgment of my Lord at 1137, it's MS 1137, paragraphs 248 to 251, where my Lord addresses the nature of the public law breach required to invalidate the detention. And it's really the top of page 1138, paragraphs 250 and then 251, reference in paragraph 250 to the statutory system of review, but then 251, breach of a public law duty which has the effect of undermining the achievement of the statutory purpose will render the continued detention invalid. And then last sentence, this approach approximates the way in which the case is put for the appellants, but links it more closely to the vital consideration of the statutory purpose of the power to detain. So we say the failure to give reasons is so fundamental, and it's really one of the reasons why I took my lords and my lady through what may seem obvious, why we have a duty to give reasons, because of the focus for the decision maker and then the nature of the decision in issue. The provision of reasons is a fundamental part of the lawful exercise of the statutory power, and that's how and why it bears on the decision to detain. And then Cambadsdy, if I might just refer to that, that was a review case. It's tab 23, starts at MS 1175. My lady at 1202, paragraph 71. Says this. There are some procedural requirements, failure to comply with which renders the detention unlawful, irrespective of whether or not the substantive grounds for detention exist, and some which do not have this effect. And then a clear distinction can be drawn between a requirement which goes to whether or not a person is detained and a requirement which goes to the conditions under which a person is detained, an example then given. And then paragraph 72, same analysis applies to requirements imposed by the common law. There are some procedural requirements that go to the legality of the detention itself, some which do not. The common law imposed a requirement that an arrested person be told at the time the real reason why he was being arrested. And then at page 1205, paragraph 80, in the judgment of my lord, paragraph 80 at letter B, the essential question must be whether there's an adequate connection between compliance with the duty and the lawfulness of the detention. And then at 81, between D and E, the reference there is to safeguards which are vital safeguards of the detainee's interests. And we would say the provision of adequate reasons is likewise a vital safeguard of the detainee's interests. So we rely upon Christian Lachinsky, Lumber and Cambadsdy to provide the foundation for the submission that the effect of a failure to give adequate and timely reasons is that the detention itself is unlawful. My lady, my lords, if I can move on in the time I have available to Article 5. And again, summarise our submissions in relation to Article 5, which are as follows. 1, Article 5(1)(e) prohibits the detention of persons of unsound mind unless the detention, both in its ordering and in its execution, is lawful and in accordance with the procedure prescribed by law. And I will go to the cases in support of this. 2, those concepts of lawful detention and procedure prescribed by law mean that a detention that doesn't comply with domestic legal requirements is contrary to Article 5(1). And it follows, therefore, that if the first part of our case is correct and there was a failure to provide adequate reasons to the appellant at common law, his detention was contrary to Article 5(1)(e), and my learned friend accepts that. But if we are wrong about the common law, we say the appellant's case may and should still succeed under Article 5, because compliance in procedural terms with domestic law isn't sufficient. Article 5 requires compliance with the principles set out in the Convention. Any deprivation of liberty under Article 5 must be in keeping with the purpose of protection from arbitrariness, And this requires, as a matter of convention rather than just domestic law, a fair and proper procedure with adequate legal protections. And all this is derived from the case law that I'll take my lady to. The European Court recognises that psychiatric patients are a particularly vulnerable group and that their hospitalisation frequently results in serious interference with their private life and physical integrity. And as a result, 3 particular elements emerge from the case law concerning their detention. Firstly, their detention can be justified only by very weighty reasons. Secondly, any interference with their rights must be subject to strict scrutiny. And thirdly, and most importantly, the procedures leading to their involuntary placement in a psychiatric unit must provide clearly effective guarantees against arbitrariness. The case law also establishes, we say, that Articles 5.1, 5.2, that's the requirement for reasons, and 5.4 are closely linked, that the failure to provide a patient with reasons for their detentions means that patient hasn't been afforded one of the fundamental procedural safeguards required by Article 5.1. It will simultaneously amount to a violation of Article 5.2, and it will in turn impact upon the patient's Article 5.4 rights. And so applying those principles to the facts of this case, what we say is Article 5 required the respondent to provide the appellant with reasons for his detention, either at the point of execution of the warrant or within a matter of hours, in other words, at the earliest possible opportunity, and that the failure to do so and to provide him with adequate reasons for 15 days resulted in him being denied the essential procedural requirements for lawful detention. And as such, his detention was arbitrary and unlawful. Now, if I can take my lords and my lady to the cases as speedily as I can manage.
Can I just hold you up just for a second?
Yes.
I appreciate the point isn't being taken, but technically, if you're right, the trespass committed against your client would be committed initially by the people who physically detained him. Is that right? And then by the hospital which kept him, which deprived him of his liberty.
No, for the reasons that have been analysed in a number of authorities, including a decision called T and Hackney, which my Lord, I think Lord Toulson was part of in the Court of Appeal. The hospital and indeed the police are entitled to act upon a warrant that on its face is valid.
Well, that all goes to the nub of the...
But for their purposes, the presence or absence of reasons does not render their actions in reliance upon the warrant unlawful. And that's been very clearly mapped out in case law. We haven't brought it, but can supply it to the court after the hearing if need be. And indeed is reflected in a number of the statutory provisions.
Well, how...
The illegality and the author of the unlawful detention, and therefore the person who in law is held to be responsible, is the person who has authorised the detention, which in this case is the Secretary of State. I will perhaps see if I can get copies of the Hackney case made available over the lunchtime adjournment.
Either the warrant authorises this person to be detained or it doesn't. And I'd have thought that submission you're making is difficult to reconcile with your argument that the detention in pursuance of a warrant was unlawful because of the absence of an adequate explanation of the grounds.
We say the decision to recall was unlawful. The Secretary of State's decision to recall was unlawful because of the failure to provide adequate or timely reasons. And that has the effect of rendering his detention unlawful. It does not have the effect of rendering the acts of those who relied upon the warrant, primarily the hospital, unlawful. Because the case law distinguishes, as I say, between the different actors that are involved. And so in the Hackney case, a failure to comply by the AMP, the approved mental health professional, with a fundamental procedural requirement of consultation with the nearest relative rendered the actions of the local authority in applying for the patient's admission to hospital unlawful. And
was it the local authority or was it the approved mental health professional whose actions were unlawful?
it was, I will have to check the report, my lady, but I think it was the local authority that was sued and was held effectively vicariously liable for the actions of the approved mental health professional. But the actions of the hospital in actually detaining the patient were held by the Court of Appeal to be lawful.
But that's governed by the Mental Health Act. There's a provision in
Well,
the
it is governed by
Mental
the
Health
Mental Health Act.
that says
Yes.
that the hospital is entitled
And
to
that's why we
rely
make no complaint
on
about the
an
hospital.
application which is duly completed.
Yes, and that's why we make no complaint and bring no case against the hospital in the present case.
Okay.
But your complaint is about the Secretary of State not having taken adequate steps to ensure that those executing the warrant on his behalf complied with what you say the obligations are.
Yes.
Is that what you're saying?
Not having taken, I think, any steps.
Yes, but
Yeah, I mean, there's no evidence, I have to say, to suggest that Mr. Hart's dissemination of that one piece of information was at the request of the Secretary of State rather than being a volitional act on the part of Mr. Hart. It may be nothing turns on it, but there's no evidence that the Secretary of State took any steps vis-a-vis in terms of the communication of reasons, other than the 5-day later letter which failed to actually set out what any of the reasons were and was sent to the wrong doctor. So, dealing with the Article 5 case law, Winter Work, Volume 3 of the Authorities Bundle, Tab 28, MS 1387, and turning to MS 1402, paragraph 39. This really sets out the general requirements in terms of procedure and lawfulness. It's paragraph 39, bottom of page 1402. Lawfulness presupposes conformity with domestic law in the first place and also conformity with the purpose of the restrictions permitted. It's required in respect of both the ordering, so the initial authorisation, and the execution of the measures involving deprivation of liberty. And then 2 paragraphs down on page 1403, these expressions, lawfulness and procedure prescribed by law, reflect the importance of the aim underlying Article 5. In a democratic society subscribing to the rule of law, no detention that is arbitrary can ever be regarded as lawful. And then just turning on to page 1405, top of the page, second paragraph, third line down, the notion underlying the term in question is one of a fair and proper procedure, namely that any measure depriving a person of his liberty should issue from and be executed by an appropriate authority and should not be arbitrary. And then the subsequent case law deals in much more detail about what's meant by fair and proper procedure. That's Winter Work. There's then, bringing matters very much more up to date, Plaiso and Hungary, tab 34, MS 1527. It's paragraph 59 on page MS 1546. The last sentence of paragraph 59. The notion underlying the expression in accordance with the procedure prescribed by law requires the existence in domestic law of adequate legal protections and fair and proper procedures. And then paragraph 65, bottom of the next page, third line down, it refers to the procedure followed not being entirely devoid of the risk of arbitrariness, reiterates that formally valid detention orders do not necessarily fulfil the requirements of Article 5.1 if not underpinned by sufficient reasons. And then reference over the page 1548, the first part of the page, the importance of recognising the particularly vulnerable group that psychiatric patients comprise, and their detention can be justified only by very weighty reasons, the importance of fully respecting their physical and personal integrity. The next case which develops these ideas is Zagadolina and Russia, tab 35, MS 1552. And paragraph 51, page MS 1566.
Sorry, what tab is it, please?
It's tab 35 and it's MS 1566. Paragraph 51 of the judgment. Halfway down that paragraph, the court highlights that the notion of lawfulness in the context of Article 5.1e of the Convention might have a broader meaning than in national legislation. And then paragraph 52, again reference to the vulnerable group, any interference with their rights, that's individuals suffering from a mental illness, must be subject to strict scrutiny. And then bottom of the page, paragraph 53, in light of the vulnerability of individuals suffering from mental disorders and the need to adduce very weighty reasons to justify any restriction of their rights, the proceedings leading to the involuntary placement of an individual must necessarily provide clearly effective guarantees against arbitrariness. And then on the facts of that case, page 1568, paragraphs 61 to 62, a procedural defect, in that case the failure to ensure the applicant's involvement in the process leading to her incarceration, was held to be a breach of Article 5.1e, and we see that at paragraph 64. The authorities failed to meet the procedural requirement necessary for the applicant's involuntary hospitalisation, as they did not ensure that the proceedings were devoid of arbitrariness. Paragraph 66, violation of Article 5.1e. And then Petkov and Bulgaria, perhaps the most directly relevant case for present purposes. It's at tab 36, page 1572. And if the court turns to page 1581, paragraph 42, again refers to the principle of arbitrariness and then says this, the reasoning of the decision ordering detention is a relevant factor in determining whether a person's detention must be considered as arbitrary. The court has considered the absence of any grounds given by the judicial authorities in their decisions authorising detention to be incompatible with the principle of protection from arbitrariness enshrined in Article 5.1. And then if the court looks at paragraph 47, bottom of page 1582, no such facts and information, that's no such facts and information as would provide a substantive basis for detention, in that case under Article 5.1c, were mentioned in the orders for the applicant's detention, which merely over the page refer to the applicable legal provisions and not to any specific circumstances or act. This alone could be a sufficient ground for the court to conclude that the applicant's deprivation of liberty was incompatible with the principle of protection from arbitrariness. And then at paragraph 54, page 1584, reference is there made to a number of the procedural safeguards in the domestic procedure, and these were all procedural safeguards that post-date the point at which the detention started. Obtaining a review, access to a lawyer, and so on. And over the top of the page to 1585, because those procedural safeguards the applicants weren't able to access, paragraph 55, top of page 1585, the court's not convinced that the domestic law provided sufficient guarantees against arbitrariness. Paragraph 56, the court concludes in view of the above that the domestic law did not contain sufficient guarantees against arbitrary detention, and insofar as it contained some, they were unavailable to the applicants, and therefore there was a violation of Article 5.1. And then in terms of Article 5.2, it's paragraphs 59 through to 61 on page MS 1585. And at paragraph 61, we see this. The orders merely indicated the applicable legal provision of, that's the domestic legislation, without mentioning any factual circumstances, the bare indication of the legal basis for the arrest taken on its own is insufficient for the purposes of Article 5.2. And then there's just a reference to the interrelationship with Article 5.4 at paragraph 67. And then this at paragraph 77 on page 1588. The court finds the domestic law did not require and the authorities failed to establish in practice, and then sets out some matters relevant to the substance of the challenge in that case. And then this, notwithstanding the formal requirements of the law, in practice the applicants were also deprived of the basic procedural guarantees inherent to Article 5. They'd not been afforded information on the reasons for their detention or access to a lawyer for the purposes of effective defence in view of these reasons. They weren't able to undertake proceedings in order to obtain their immediate release, and then a reference to inability to seek compensation. These circumstances are incompatible with the purpose of protection against arbitrary deprivation of liberty enshrined in Article 5. And so we see there a very clear case of an absence of reasons rendering the detention unlawful for Article 5 purposes. And indeed, the court really considering Article 5.1 and Article 5.2 compendiously in paragraph 77. And then...
Absence of reasons for how long?
I think it was in the region of 24 hours in that case.
Oh.
The facts are at page MS 1574. They were taken to a police station at around 4 o'clock, that's paragraph 7. Around 6 o'clock, they were given the written orders for their detention for 24 hours, which didn't mention the factual grounds. And then they were released, this is paragraph 10, at 5:15 on the next day. So they were detained for approximately 24 hours without being given adequate reasons.
Thank you.
And then Mifabova and Russia, tab 37. Again, this is a further example of the European Court concluding that procedural deficiencies, the absence of a fair procedure, rendered the detention a breach of Article 5.1e. It starts on MS 1591, but the relevant passage for present purposes, perhaps starting on page 1606, paragraph 56. Paragraph 56 refers to the substantive requirements of Article 5.1e, and then in the last sentence, the procedural requirements, an obligation to ensure the procedure leading to detention is fair and proper and devoid of arbitrariness. And then there's reference to the absence of adequate opportunity for participation in paragraph 57. And then over the page at 65, there's reference to a number of procedural deficiencies, again, which post-date the detention or the commencement of the detention. Reference to the failure of the domestic authorities to provide her with a full copy of the authorisation for her involuntary treatment, that she was unaware of the reasoning given by the town court and therefore was forced to confine a statement of appeal to expressing discontent. Paragraph 66, the court concludes that the competent national authorities, so in light of the above findings, the court concludes the competent national authorities failed to meet the procedural requirement necessary for the applicant's involuntary hospitalisation, since they failed to ensure the proceedings were devoid of arbitrariness. And then finally, in terms of the Article 5 case law, tab 38, MS versus Croatia number 2, MS 1611. Four short points. Paragraph 139 at MS 1663. So that's the wrong reference. Paragraph 139, MS 1663. Article 5 in the first rank of fundamental rights within the Convention, perhaps obvious. And then at 1664, paragraph 147 emphasises the need for clearly effective guarantees against arbitrariness in procedural terms. And then paragraph 154, top of page 1666, refers to the constant line of principle articulated by the European Court in paragraph 154, that the Convention guarantees rights that are practical and effective and not theoretical and illusory, and then goes on to discuss a number of the procedural defects. And then paragraphs 157 and 158, bottom of 1666, reference there to ineffective access to justice, no evidence that he, that's the judge, informed the applicant of her rights or gave any consideration to the possibility for her to participate. And then in paragraph 158, she was not given an opportunity to comment on the expert's findings. These procedural defects were found to be render the detention unlawful. That's paragraph 160 on page 1667. Now, having regard to that case law, all of which, with the exception of Winterwork, is relatively recent case law of the European Court of Human Rights, we draw together the principles and emphasise a number of factors. The fundamental nature of the right protected by Article 5, the vulnerability of individuals suffering from mental disorder, the interference with private life and physical integrity that may result from compulsory hospitalisation, the stated need for very weighty reasons to justify detention under Article 5(1)(e), the requirement in Convention case law for a fair and proper procedure as an inherent component of the lawfulness of the detention, and in particular the need for the procedure to ensure clearly effective guarantees against arbitrariness, the principle that no detention that is arbitrary can ever be regarded as lawful, and then the fact recognised in a case I haven't taken my lords to, but my lady to, it's X in the UK, it's in our written case, but the fact that the prompt provision of adequate information is one of the elemental safeguards of a fair procedure and essential to enable an individual to exercise his Article 5(4) rights. Having regard to all those factors, we say that it's clear that under Article 5, the reasons for the recall of a patient to hospital must be provided, and they must contain a clear explanation of the central reasons for recall. They must be provided promptly, both because that's fair for Article 5(1)(e) purposes, but also because promptly is the language of Article 5(2). And in light of a submission my learned friend makes in his case, I actually looked to see what the Oxford English Dictionary definition of promptly is. I've got copies which we can provide if need be. Readily, quickly, at once, without delay, directly, forthwith, there and then. And I think the French equivalent translates as in the shortest period or in the shortest time. So promptly, we say, translates to time of recall, or if that's impractical or impossible, within a matter of hours. It's clear, for the reasons I've already given, and I don't need to repeat, that this appellant didn't receive adequate or timely reasons, and indeed that there wasn't compliance with the respondent's own policy. And for all those reasons, his detention was arbitrary and in breach of Article 5. The Court of Appeal relied upon 3 older European Court of Human Rights cases to justify its conclusion, which we say was erroneous, that Article 5 didn't require the provision of reasons when detained, and for concluding that there was no breach of Article 5(1). I'll just deal with them very briefly because I'm conscious of the time and my learned friends need to make his submissions. X in the UK, and I'm not going to take the court to any particular passage, but I'll give the court the references in the bundle. It's tab 29, MS 1416. is a case decided 35 years ago, and in both conventional and domestic law terms, the understanding of what's required by way of fairness has developed rather significantly in the intervening 3.5 decades. And in any event, it wasn't argued by the applicant in that case that the failure to provide reasons or the breach of Article 5.4 had the effect of rendering his detention unlawful. It's hardly surprising it wasn't addressed by the court. Van der Leer in the Netherlands, which is tab 30 MS 1456, in that case a procedural defect, not reasons, but a failure to hear from the applicant or give reasons for dispensing with the need to hear from her, led to a finding of a violation of Article 5.1 because of a failure to comply with an essential procedural defect. The court found a violation of Article 5.2 the Court of Appeal apparently inferred from Van der Leer that the fact that the applicant had not been informed of the reasons or the fact of her detention didn't amount to a breach of Article 5. And that's the Court of Appeal's judgment, paragraph 35, MS 137. That's just wrong. I can come back to it by way of reply if I need to. My learned friend relies upon it to some extent.
Sorry, which paragraph from the Court of Appeal's judgment?
35, MS 137. The Court of Appeal may have meant that the European Court didn't make the link between reasons under Article 5.2 and unlawful detention under Article 5.1. But again, that point wasn't argued and therefore unsurprisingly wasn't addressed by the European Court. And then the third case relied upon by the Court of Appeal, Fox, Campbell and Hartley, tab 31, MS 1466. Again, a relatively old case, decided I think 25 or just over 25 years ago, not necessarily in keeping with the rather more modern case law which I've taken the court to in relation to the requirements, procedural requirements. But in any event, the facts there, in the particular context of that case, were that suspected terrorists were informed that they were being arrested under a particular section, and that was because they were suspected of being terrorists. Later in the day, the reasons for that suspicion emerged in the course of interview and interrogation. And that interval of a few hours in the context of that particular case wasn't, the court held, outside the constraints of time imposed by Article 5.2. Again, the applicants didn't argue any procedural defect for Article 5.1 purposes, so again, unsurprising, the court didn't deal with it. Perhaps I should just show you, however, one passage in it before I leave the European case law.
You've 3 minutes left.
Yes, I know. Well, perhaps I'll give my lords and my lady the reference. It's MS 1479, paragraph 40. What the court said was whether the content and promptness of the information conveyed, in other words, the reasons given, was sufficient, is to be assessed in each case according to its special features. So essentially cases turn on their own facts, and so no particular inference to be drawn one way or another from Fox, Campbell and Hartley, and the Court of Appeal's reliance upon it was therefore misplaced. That, I think, completes the principal submissions on Article 5 and the reasons why we say there was both a breach of Article 5.1 and 5.2 and that the detention was unlawful. The only issue that leaves is the issue of relief, and I can deal with that very briefly. In relation to unlawful detention, if we succeed in establishing that there was unlawful detention, we confine the relief that we seek to declaratory relief and nominal damages. We do that for two reasons. One is Lumber makes clear that the entitlement at common law would be to nominal damages only. And although in our written case we had advanced a claim for modest damages under Article 5 for unlawful detention, we had overlooked what the European Court said in the HL case, and I won't take up the court's time by providing a copy, but we have copies if need be, but there, the famous Bournemouth case, effectively the European Court of Human Rights took a Lumber type approach, where there were procedural deficiencies if the detention would still have resulted had those procedural safeguards been complied with, then normally the finding of the violation will be just satisfaction and no damages will be awarded. So for that reason, we do not press the issue of damages for breach of Article 5. We say that for the reasons we've set out in our written case, that a declaration nonetheless should be made if we are correct on the issue. And in relation to what was an acknowledged breach of Article 5.2 by the Court of Appeal, again, we say that there should be a declaration, given the importance of these issues and the importance of these rights. And the Court of Appeal provided no reasons for not doing so. We've set that out in our written case, I won't repeat it. We do say that there is, under the case law that we've referred to in our written case, a entitlement, applying the principles correctly, to modest damages for the distress, anxiety, non-pecuniary damage that would be occasioned by reason of being detained without knowing why. And my lords and my lady have seen the statement of the appellant in that regard.
Sorry, just for the avoidance of doubt, which is the case law that you say you rely on for that?
It's Greenfield and Faulkner, both of which are in our written case.
Well, yes, well, Greenfield's a very familiar case.
Yes.
But it indicates that but we are required by the Act to look at any Strasbourg jurisprudence. Are there Strasbourg cases which deal with the adequacy of a declaration for a Article 5.2 breach case where there's not a breach of Article 5.1?
I have not found any Strasbourg cases which deal with it in terms of articulating principles. The majority of the cases that are in the bundle where damages were sought resulted in a modest award of damages.
But those were 5.1. Those were 5.1. Those were unlawful detention cases.
Well, there's a mix, in fact, and you can't.
But I'd be
can't detect from the case law to what extent the damages are payable for Article 5.1 or Article 5.2.
Right. Well, I would be interested to know whether there are any clearly distinct Article 5.2 cases where the Strasbourg court has confined itself to a declaration or awarded damages, and if so, what the compensation has been.
None that we've been able to find that look at Article 5.2 in isolation from
Right.
others.
Thank you.
So, for example, Petkov, which I referred to, the court looked compendiously at the Article 5.1, 2 and 4 breaches and made a compendious award of damages.
So in relation to 5.2 alone, we get no guidance from Strasbourg.
No, we do get some guidance from this court's decision in Sternum, which was looking at Article 5.4 and distress and anxiety, which couldn't be shown to have had a causative effect in terms of the prolongation of detention. And their modest awards of damages were made in the region of £500, £600.
Do any
And
of the
that's only
IPP
guidance we
cases bear on this?
Well, my learned friend relies upon them, and I'm proposing in light of the time to deal with that by way of reply,
Thank you
if I
very
may.
much.
But they don't bear on the issue of quantification.
Ms. Richards, in the Court of Appeal, was there this suggestion that there might be modest damages for the admitted Article 5.2 breach?
I believe so, but as I wasn't involved, may I just turn to my
Thank you.
learned friend?
Perhaps that could be, if
certainly-
it exists, perhaps that could be found.
Thank you.
Because I don't think there's any reference in the judgments to that.
No, I've certainly seen a note on damages that was prepared for the purposes of the first instance judgment, and it was clearly in the claim form and grounds, but I will check that point in the course of the day. In view of the time, my lords and my lady, I think perhaps I should sit down and leave Mr. Chamberlain to his time.
If the Hackney case is material, and frankly, I have no recollection at all whether it is, it's in 2011 One Weekly Law Reports 2873.
Yes, I've got my own copy of it
Oh,
here,
you've got
so
it,
I will
right,
check
there
and
we
if need be give hard copies out.
Thank you very much, Mr. Richards. Mr. McKendrick?
Nothing, my lady, to add at this stage.
Thank you very much. Mr. Chamberlain?
Lady, my lords, I propose to take the same course as my learned friend, that's to say to deal with the common law first, then to move to Article 5, and finally to address briefly the question of damages. Just while we're on the topic, we have located the Hackney case and we have got copies of it coming for the court this afternoon.
I'm sure that would be helpful.
Yes.
I have been trying to locate it on the internet, but it's not working very well.
It's EW 2011 EWCA Civ 4.
Yes. Lady, my lords, can I start with the common law claim and start by summarising what is and what is not in dispute? It is common ground, as we understand it, in the light of the unchallenged findings of Mr. Justice Dingemans, that this court ought to proceed on the basis that when the decision was taken to detain the appellant, the Secretary of State's decision maker had good reasons for the detention. It's also common ground that both the Secretary of State's policy and the common law require not just that the decision maker should have reasons for detaining a patient, but also that he or she should communicate them. There is a dispute about when reasons have to be communicated and how much reasons have to be communicated. The appellant says that adequate reasons have to be communicated at the moment of detention. But as has been pointed out this morning in questions from my Lord, Lord Kerr, what does adequate mean? Adequate for what purpose? We say that what needs to be communicated at the moment of detention is a reason that is adequate to convey the ground on which the power is exercised. And we say that for the purposes of this case, you're being detained under Section 42(3) of the Mental Health Act because your mental health has deteriorated, was in this case sufficient. Thereafter, the policy requires the provision of further reasons, that's to say, reasons that would withstand a reasons challenge in judicial review proceedings as soon as possible and in any event within 72 hours, with written reasons within 72 hours. And we say that providing that this is done, there is no basis for the common law to impose any more stringent requirement. Now, it is common ground that by failing to communicate further or full reasons within 72 hours of the detention, the Secretary of State breached his public law duty. And it's also common ground, as we understand it, that some breaches of public law duty in relation to a detained person render the detention itself unlawful, but others do not. In the former case, the consequence of the breach is that the individual is entitled to immediate release, and if not released, has a claim for false imprisonment. In the latter case, the proper remedy is an order made in judicial review proceedings directed to remedying the breach. And the main question in this case is which of these two kinds of breach occurred here. Now, ladies and lords, I'm going to deal with the reasons provided at the moment of detention first, and then consider what consequences, if any, flowed from the delay in providing further and fuller reasons after the decision to detain had been both made and effected. So can I start by dealing with the moment of detention on the 19th of July 2012?
Can I just ask, so to understand the framework?
Yes.
When you talk about a common law duty to give the grounds of detention and the legal basis of detention at the time of the detention itself,
Yes.
That's, I suppose, an aspect of procedural fairness.
Well,
or what is it?
Well, it's a requirement that comes from cases like Christie and Lichinsky.
Yes, okay.
It's there for a particular reason, and this really supplies the answer to my Lord Kerr's question. What does the ground have to be adequate to convey? Well, it has to be adequate, as one sees from the reasoning in Christie and Lachinsky. I'll come to this in due course, but I want to answer the question now, if I may. One sees from the reasoning in Christie and Lachinsky that the reason why the common law implies an obligation to provide the ground is because in our country, an individual is entitled to resist an arrest or a detention unless told that there is a lawful ground and given the lawful ground that exists. One sees that from Christie and Lachinsky. And that, of course, informs the quality or the content of the reason that must be given at that stage. So when one asks the question, what was the reason adequate for? What does it have to be adequate for? The answer is adequate to supply to the individual the information he needs to understand that he is lawfully obliged to submit to the arrest or detention. And that comes out, as we'll see when we look at it in more detail later, from the reasoning of the speeches in Christie and Lachinsky. The lumber ground, as was pointed out in argument by several of members of the court when my learned friend was on her feet, is a different point. That arises after the decision to detain has been made and effected. It supplies an additional obligation on the Secretary of State to provide fuller reasons, and there the reason for the reasons requirement, the underlying rationale for imposing an obligation to give fuller reasons at that later stage, is to enable the individual to know whether he or she has a basis for challenging the detention, whether in judicial review proceedings or before the tribunal or whatever. And so when one asks the question, what kind of reasons would be adequate for that purpose, one is asking a different question. And that's why the reasons that are given at that later stage, within 72 hours at the latest, have to be fuller.
So the common law duty at that stage is not derived from it's not based on the effect of the published policy.
No, indeed so. Indeed so. The published policy actually doesn't say anything about reasons at that first stage, other than that the individual has got to be told, which is at least something, that they're being detained under the Mental Health Act, under Section 42(3), and not under some other power. So clearly they have to be told that. But the common law requirement may go somewhat further, but as I'll come to show, not very much further. Now, before looking at the authorities...
Looking at it in historic common law terms,
Yes.
would the common law have required the provision of that information? The position of somebody who was detained and asserted his detention was unlawful would be by habeas corpus, and in response the defendant would have to justify the detention. At least that's how I understood the common law worked.
Absolutely.
Detention was all detention is prima facie unlawful. Therefore, the person detained applies for habeas. At that point, the defendant has to justify it. You say that's not the common law today.
Well, my lord, as a basic proposition, we agree with that. There is a slight overlay that's put on it by Christie and Lachinsky, because we know from Christie and Lachinsky that the police cannot simply lay hands on somebody and take them into custody without telling them something very basic about the basis on which they are being detained. And that something very basic is, as my Lady Hale put it in argument, you are under arrest on suspicion of murder. That's it. Now, that is something...
The consequence of not saying that would be to make it unlawful and therefore make him entitled to his immediate release by way of habeas corpus.
Or indeed to resist arrest.
Or to resist arrest.
And that's an important alternative when we come to see what the consequence would be if my learned friend were right.
And recover damages.
And indeed, yes.
For unlawful imprisonment.
And indeed, yes, damages also. I mean, of course, that consequence is perhaps a less frightening one in the light of the change to the law of false imprisonment effected by the decision of this court in Lumber. But the entitlement to resist arrest and the entitlement to an order as of right for release in habeas corpus proceedings are important consequences that would flow if my learned friend is correct. I'll come to show that in just a moment. But before I do that, can I just make 3 contextual points about the practicalities of giving reasons in detention cases generally and in the context of recall under the 1983 Act in particular. Now, some of these can be seen from the policy itself. And I mean by the policy itself, I mean the policy that was in force and is in force, which you've seen at the end of the core volume. It's core volume, MS, page 161. So if you just have that open. Now, the first contextual point is that the person being recalled, this is a point that my Lady Hale made at the outset, is that the person being recalled is necessarily someone who knows that he or she is subject to recall and whom the tribunal has held requires ongoing clinical supervision. And my lady asked for whether there was anything in the bundle that showed what the patient had in fact been told. And there is, because it's actually set out in the decision of the tribunal, which is in Appendix Part 2, page 334, MS 440. So one can see from that that the decision of the first tier tribunal makes it clear, 335 under the heading decision, patient shall be conditionally discharged from liability to be detained in hospital for medical treatment, but the patient will remain liable to be recalled for hospital for medical treatment should it become necessary. The conditions are then set out and the reasons are given. So that's the first contextual point. And we respectfully agree with the point made at the start by Lady Hale that puts this patient in a different position from somebody who is not subject to any prior restraint, even a contingent one, on his or her liberty. The second contextual point is that the person who actually effects the detention may or may not be part of the team responsible for the patient's clinical supervision. And one can see that from the policy itself, MS page 161, under the heading background. Readmission to hospital, bottom of that paragraph, should be by arrangement with the receiving hospital and the local social services department. The person responsible for taking the patient back to hospital could be a police officer, probation officer, nurse, approved social worker, or any other person authorised by the hospital managers. So that's who's actually effecting the detention. The third contextual point is that there are, as the policy makes clear at the top of 162, obvious difficulties in asking the person who effects the detention to give a full account of the decision which led to recall. One reason for this, as the policy makes clear in the first sentence, 1.1, is that the patient may be in an excitable and nervous state. Now, it's said here that the appellant wasn't in such a state, but is it really being suggested that the individual who effects the detention, who may have no medical training at all, is required to assess how excitable or nervous the patient is, and if he gets that wrong, that assessment wrong, the consequence is then that the patient is unlawfully detained. In any event, it may be counter-therapeutic and inappropriate for other reasons for a detailed discussion about the state of a patient's mental health to take place with or even in front of police or probation officers. That is why the policy, then and now, suggests a very limited reason-giving requirement at the point of detention. In this case, the appellant was told first that he was being recalled under Section 42(3) of the Mental Health Act, and second, that this was because his mental health had deteriorated. Now, we say that both of these pieces of information told him something of importance. Recall can take place following some form of criminal conduct. It is frequently effected by police officers, as it was here. So being told that the detention is under Section 42(3) of the Mental Health Act conveys that the patient is not being detained pursuant to an allegation of criminal conduct, but under powers conferred by the Mental Health Act. To say that a person is being recalled under Section 42(3) because of a deterioration in his mental health is not simply reciting the statutory precondition for recall. It is adding something of substance. And that can be seen by looking at the Secretary of State's policy document at Appendix 2, page 370, MS 476. Now, this is the document which you have already seen, which sets out the basis on which the decision to recall will be taken. But if one looks
What page is this? I'm sorry, Mr. Chairman.
I'm sorry, the start of that document is 370,
Thank you.
Appendix 2, MS 476.
Thank you.
But the bit I'm going to ask your ladyship and your lordships to look at is at 375, MS 481, and it's the penultimate bullet point. There is no need for the patient's mental health to have necessarily deteriorated in order to justify recall. If a patient has a mental disorder and is presenting an elevated risk linked to that disorder that warrants detention in hospital, then the patient can be recalled. In such a case, the criteria for detention would be met because the disorder was of a nature rather than a degree that warranted detention in hospital, and this is necessary for the protection of other persons. So the point that arises from that is that deterioration in a patient's mental condition is one, but not the only reason for which recall might be, for which a decision to recall might be made. The final bullet point makes the point that similarly, where the primary concern relates to deterioration or potential deterioration in the patient's mental state, then this will be evidence that the disorder is of a degree that warrants detention in hospital. Now, in this case, we've set out at paragraph 40 of our printed case the circumstances leading to recall on the 19th of July 2012. And we make the point there that the person who told the appellant that he was being recalled was Mr. Hart, the social supervisor, and that Mr. Hart had had a conversation with the appellant on the very day of recall, and we've set out what was said in that conversation. So if one asks the question contextually, what would the patient have understood by being told that his mental health had deteriorated? Well, it has to be seen in the context that he had been speaking to his social supervisor, the man effecting the recall, earlier that day, and must have known what was said between them. Now, we say that this is consistent with what you see in the most recent Mental Health Act Code of Practice, which, as you know, is the last tab in Volume 3, tab 39, in Authorities Bundle 3, MS 1679, which requires, as you recall, a brief verbal explanation at the time of the moment of recall. And it also requires, my learned friend made something of the word detail. It requires that the Secretary of State's warrant will detail the reasons. Well, so that I'm clear about what the policy is simply that the brief verbal explanation which is given at the time of recall, which we say could be something as simple as because your mental health has deteriorated, is reflected in the warrant.
Yeah.
The warrant doesn't... Sorry.
I'm just wondering, should that not perhaps always have been the case when one thinks about the background law relating to warrants, against the background of which Section 42 was enacted?
Well, my Lord, if that point comes from a concern about general and specific warrants and the case law relating to that, we say that this context is rather different, because we're not talking simply about a warrant where when one gets it, one has no idea as to what the real ground of detention is. This is a warrant under Section 42(3) of the Mental Health Act, issued in respect of somebody who knows that he or she is subject to recall under that Act. And he doesn't just know that he's subject to recall under that Act, he knows why, because he's been told in terms by the Mental Health Review Tribunal. So when one asks what are the formal requirements for the warrant, in terms of an analysis of how one would read Section 42(3), then there's nothing on the face of 42(3), and there's nothing in the common law, case law on general and particular warrants that would require anything more. The policy says, and I think my learned friend and I are actually ad idem on this, that it doesn't matter how the reason is communicated, whether it's communicated by a brief oral reason or whether that brief oral reason is also reflected in the warrant. The important thing is that adequate reasons are conveyed. And so the key question in this case is not whether the warrant was defective, but whether the reason which was undoubtedly communicated was adequate for the purpose that we're dealing with when we're looking at the original initial detention. And that purpose, as I've explained, is the purpose of conveying that there is a lawful ground for the detention and that the individual who is being detained is not entitled to resist arrest. And for that purpose, given the context that I've explained and the difficulties that there would be of getting into a lengthy discussion about a patient's mental health in front of detaining officers, given all of that context, the common law requirement is simply to be told, as in Christian Liczynski, you're being detained under Section 42(3) of the Mental Health Act because your mental health has deteriorated. Now, I do want to look in some detail at Christian Liczynski, and that is in Authorities Bundle 1, tab 4, MS page, the paragraphs that I'm going to go to are at MS page 605 to 606. But I see the time and wonder if the point to move to that case may be...
Well, there are 2 minutes left to you. What do you want to say in 2 minutes?
Well, I will... I was going to draw 3 things from this case, and perhaps there'll be time to draw the first of them. So, the first point is that in this country, an agent of the state cannot simply detain someone without communicating a lawful ground for detention. For example, you're under arrest on suspicion of murder or burglary or whatever it is. Why is that? Well, we say you can get that from page 591 in the speech of Lord Simons, just below the middle of the page. I would say that it is the right of every citizen to be free from arrest unless there is, in some other citizen, whether a constable or not, the right to arrest him. And I would say, next, that it is the corollary of the right of every citizen to be thus free from arrest that he should be entitled to resist arrest unless that arrest is lawful. Exactly the same point over the page in a speech, in a citation from Lord Cranworth, which is also set out by Lord Simons towards the bottom of that page. The purpose of the requirement is so that the person arrested may know whether he is or is not bound to submit to the arrest. And
that's in the context of civil proceedings. I think that that dictum.
yes, well, it doesn't actually matter because we're talking about a detention, a power to detain. And so I accept that that was in the context of civil proceedings when it was possible to execute writs by detaining. And if one then goes on to 598, one can see exactly the same point comes out from the speech of Lord du Parc, the bottom of page 598. Principle as established by the authorities are agreeable to common sense and follow the governing rule of the common law, that a man is entitled to his liberty and may, if necessary, defend his own freedom by force. If another person has a lawful reason for seeking to deprive him of that liberty, that person must, as a general rule, tell him what that reason is, for unless he is told, he cannot be expected to submit to arrest or blamed for resistance. The right to arrest and the duty to submit are correlative. And this facet of the reasoning is in fact picked up in the judgment of my Lady Hale in Cambadzi, which I'm going to come to after lunch. But we say that that is a very important starting point for understanding the question which my Lord Kerr asked in the course of argument: adequate for what purpose? And for what purpose do the reasons have to be adequate? The purpose is very different at the initial moment of detention from the purpose that emerges later when the fuller reasons are given within 72 hours.
That seems like a convenient moment. We'll look forward to hearing from you again at 2:00. Court is now adjourned.